Welcome to the monthly webinar series for the New York State Technology Law Center. This is Professor Shubha Ghosh. I'm the director of the Technology Law Commercialization Program and the Crandall Melvin Professor of Law at Syracuse University College of Law. And today we have two guests with us I'm very excited to mention. Professor Sean O'Connor, who is actually on sabbatical from the University of Washington this year and is in Strasbourg, which I think it's about probably 7 p.m. in Strasbourg now. And we also have Professor Lateef Mtima, who is with me in the studios in Syracuse from Howard University Law School. And we're going to talk about an interesting copyright decision in music copyright. It's a dispute between Marvin Gaye and Pharrell Williams involving the musical number Blurred Lives. I'll turn it over to our two guests in a few minutes to give us some background, but I'll just set some general parameters. It's just, first of all, exciting to have kind of two guests to share ideas with and have a discussion about issues in intellectual property and also in copyright law that probably doesn't get enough attention in the technology commercialization world. So hopefully we'll have some chance to talk about copyright more broadly. But starting with this particular very interesting case involving music copyright, we'll have some visuals and audio later on. But let me turn this over maybe to Professor O'Connor to maybe give us some background on the lawsuit and where things stand now.
Sure, okay. So the two songs are Got to Give It Up by Marvin Gaye, which came out in the late 70s, and the song Blurred Lines by Robin Thicke and Pharrell Williams, they came out a few years ago. And public commentary on this goes completely polarized. People listening to it, some say the songs sound exactly the same, some say they don't sound anything alike, and so this ended up in a court of law, not surprisingly. And so the issues that we want to drill down on today, though, are, first, is the song as it's deposited with the Copyright Office, the Got to Give It Up song, is that what's called a lead sheet? Okay, is the music contained on that infringed by Blurred Lines? And if whether or not that is, the second question is, should the lead sheets that were used with the Copyright Office be the defining version of the work? And so what we're going to try to compare a little bit here is that a copyright deposit is not exactly the same thing as a patent application and the claims in a patent, in which you really are saying, here are the metes and bounds, here are the boundaries of what I'm claiming is my invention. And so that's what we want to explore, and what Lateef and I are excited about with this case is that we have a particular social justice angle, which is that the way the Copyright Office used to have composers submit these lead sheets in written music notation didn't work for a lot of pop composers who did not write in that sheet music format. And even if they did, that kind of European written notation format didn't work very well for the kind of music they were doing. So that's the key issues that we're going to try to get at today. Let me turn it over to Lateef and see if he wants to add anything as introductory comments there.
Yeah, no, as usual, Sean, you have captured the principal issues in the dispute. One or two things that I might add. One, to pick up on your last point about the difference between certain types of composers and certain type of genres, whether or not they are fluent in musical notation, whether or not they rely upon that as a form for composing music and/or for recording their compositions of music in terms of a written form. I think that not only are you absolutely right that an undue reliance, a reliance that is not required by the statute on those particular approaches to musical composition, not only does it disadvantage various marginalized groups and marginalized musical genres, but I think it goes even further. I think that it also goes to needlessly disadvantaging American music as a whole. Much of our emphasis and reliance upon Western classical musical notation, really comes from the European classical regime. And obviously, a lot of American music right? I mean, American music today, it is comprised of so many original music art forms. American music pretty much dominates the global scheme. And so, why would we continue to be pigeonholed in an approach to musical composition and to musical notation that was really originated in a different society for different musical genres? Sometimes I want to just sort of send an email to predominating American musicologists and say, hey, Flash, American Revolution was successful. Okay, so we're no longer limited to looking at music from this very isolated standpoint. The other issue to pick up on your discussion in which you just so aptly described the problem with the lead sheets is that in addition to this question of are we restricted to the lead sheet or not restricted to the lead sheet. There's also, sort of an ancillary question that there are aspects, elements in Marvin Gaye's work that just should be denied copyright protection per se, right? And so that arguably, if you were to take that position to its further extrapolation, if you had a lead sheet that was, a more complete version, that somehow referred to or presaged some of these other elements. Okay, there are certain elements in certain genres that outsiders, people who may be experts in other areas of music, look at those aspects and those characteristics and arbitrarily label them unprotectable style, unprotectable genre. And so even if there was a way in which you had them present or indicated, in written notation, there's also that question. So, what, putting aside the lead sheet, written notation of law, but even beyond that, what creative aspects of these different musical forms are going to be considered protectable under the copyright law, which again is something that is not expressly enumerated or dictated by the copyright statute.
And so we're not able to play the two musical works here because of technical issues, but you audience members were sent links, and if there are any questions about listening to the links, and we'll look at the lead sheets and the sheet music in a few minutes as well. But just to provide, that was very good, excellent setting up the broad parameters. I wanted to also mention that Professor O'Connor, Professor Mtima, and entertainment lawyer Lita Rosario had a very interesting Seattle Times editorial earlier this year about this case, and we can provide a link to that as well for those who are interested. And so the basic ideas behind the case, putting it very simply, is Marvin Gaye is essentially alleged copyright infringement of his work by Pharrell Williams and Robin Thicke, and the jury found in favor of basically the standard for copyright infringement that we want to focus on here is substantial similarity between the two works, and specifically substantial similarity as to the original elements of Marvin Gaye's work. So, Sean, do you want to talk a little bit more about that substantial similarity standard and how that, as you both laid out fairly broadly, got applied in this case?
Yeah, so the way that gets handled, especially in the Ninth Circuit, and this was a case that is now in front of the Ninth Circuit and was in a Ninth Circuit district court before, is basically looking at first extrinsic and then intrinsic tests. And extrinsic, the easiest way to think about it is it's the judge, and often with the input of musicologists from each side, trying to define what the work is and what are creative elements in the work that are protectable. And once those are defined, if it looks like there is some overlap, then the judge can then send it to the jury for the intrinsic test, and then for the jury to say, okay, now taking both songs together, do we think that there's infringement going on of the protected elements? So looking at that difference between the extrinsic and intrinsic test, this has troubled some people because they feel like the extrinsic test should be more of a gatekeeper perhaps than it was in this case, and that on the flip side, the extrinsic test should be more of a filter that narrows what the judge can do, and some people felt like they didn't narrow it for the jury in this case. So that's some potential problems with the Ninth Circuit's test. But let me step back a moment and say sort of a different view of substantial similarity, which is to look at, again, if we're saying that the copyrighted work is determined by a written notation, then we have to look, just like we do in patents, at the actual literal terminology that's used. But then we also, just like in patents, can look at the doctrine of equivalence and say, okay, so it's not exactly tracking the claims, but it's a obvious or simple change that's not germane to the substance of the invention. And so that's what substantial similarity is in copyright. The other work doesn't have to be identical in every last respect from start to finish, but it has to be that it clearly is taking the core elements of the original work and then using those in essentially a kind of free-riding, infringing way.
Do you want to walk us through a little bit on the literal aspects of this by showing us the lead sheet and then the sheet?
Absolutely.
That might make
Okay, so we're first going to pull up the lead sheet. And let me just talk about what we mean by that. The lead sheet is something that is not the full commercial published sheet music that any of you in the audience who play music would have seen. What you normally see, and what I normally see as a musician too, is we go to the store and we buy something like this, what's on the screen now. So this is the official sheet music for Got to Give It Up, and we just have a sample of it here. And what you'll see in official published sheet music is on the, oh wait, hold on, let me grab my, sorry, I'm using my own cursor and not the official pointer. There we go, now we have an official pointer. This, what's called a staff, for those of you who know music, this is a staff, the line's going across, this is a staff, and this is a staff. This one with that symbol there is treble clef, and this is the key signature here. And then this line is showing you the vocal melody line, the main melody. In commercial sheet music, they'll have that main melody, and then they'll have what essentially is a two-handed piano part down here. So these two staves go together. There's a treble clef and a bass clef, and this is the right hand on the piano, and this is the left hand. So this now tracks along underneath the melody line. And so the idea with this commercial sheet music is a beginning to intermediate level piano player could sit down, could play a two-handed part, and somebody, the pianist or somebody else, could sing over the top. You'll also note that they often put chord diagrams up here for guitarists. And so in this case, it says the name of the chord, A7, and then it also shows how you would play that on a guitar. Okay, so those are the main elements of commercial sheet music. But now let's flip back to the lead sheet. And notice now that the lead sheet is a lot more sparse. So the lead sheet actually only has, here's your treble clef, here's your melody line. And now it doesn't show you how to play that chord A7, but it just says A7. There is no piano part in here. There is just a melody line. So what's the point of these lead sheets? Well, they have two main purposes in music. One is a version of something sort of like this is used by a lot of us in what we call cover bands when we're playing somebody else's songs. And if you're playing at a wedding or a nightclub, as I used to play a lot at, and people are going to make requests and you might not know the song, you have a big fat book of what's often called a fake book. And it has these really stripped down versions of songs. Now, I, as a musician, could only play those if I already had heard the song, and then I remember, oh, okay, yeah, there's that A7 chord, and oh yeah, here's the melody line, maybe the saxophone's going to play that, and then, we remember the key, and then we can kind of comp along, and we kind of make it up, but we fill in a lot, because everything that's needed is not in this to play. So that's one main use of lead sheets, and they're a lot more compact, that's why we use them. And the second, let me just say the second and then Shuba. The second is that in the Copyright Office, a practice developed in the mid-20th century of publishing houses sending in a quick down and dirty lead sheet to operate as the registration for the song, partly because I think they were worried about timing issues. the publishing house and the label that was associated with the publishing house were going to release the song, and they were nervous about not getting the registration in time. So somebody, often not the composer, would write this stripped down lead sheet and submit it as the registration. I'm sorry, Shubha, you were going to say something.
About the registration. So the lead sheet was what was deposited, part of the registration, and then was the sheet music also registered, or is that something that's
No, that's the crazy part. So this lead sheet right here that we've shown for you all, this is the copyright registration. So in other words, I took this out of the whole document that was the copyright registration. And we can probably make that available to people. You can see it in the record of the case, of the Got to Give It Up Blurred Lines case. This is one of the exhibits. And so you'll see all of the documentation for the copyright registration. And then this essentially is at the end of all that. So again, it's tempting to think about it like claims at the end of the specification, right, but it plays a slightly different role.
Yeah, and I'm certain that, a question that probably almost immediately arises in some of the minds of our audience is, wait a minute, okay, why the heck would anybody ever just submit a lead sheet as a copyright registration deposit, right? I mean, if I write a novel, right, and I'm going to send in a copyright registration deposit, well, I'm probably going to send in the novel, right? I'm not going to send in the outline that I was working on before I did the completed work. One of the relevant issues here, and again, part of the social justice impetus that Sean and I have in becoming involved in this particular dispute, is that during that period in the 19th century, in the 20th century, although the statute does not require it, the statute just says, okay, put in a deposit, for reasons that are to some extent still shrouded in mystery, but we have some theories as to why we think the Copyright Office did it. The Copyright Office on its own promulgated a regulation that said, all right, the only thing that we're going to accept during this period of time is written notation. It has to be a written version of the musical composition. Now, obviously, a musical composition, even at that time and since, it can be embodied in other formats, right? In the early part of the century, it could have been embodied in a mechanical piano roll. Later there were other formats. Of course, by the time you get middle of the century, vinyl, records are, sound recordings, et cetera, et cetera. And the Copyright Office just made this decision that, well, the only thing we will accept is the written musical notation. Now, the most important thing to remember about that is that is not dictated by the statute, right? So failure to comply with this is failure to comply with the regulation, but it's not failure to comply with the statute. At the same time, the statute extends copyright protection to all of the creative elements of the work, right? So it creates this question as to, well, what happens if the deposit, in order to comply with the Copyright Office regulation, ends up being less than the work, right? Obviously, from a legal standpoint, statute trumps Copyright Office regulation, but we still have this question of, well, why would recording companies submit a lead sheet deposit as a lead sheet as a deposit? Why not put in the entire work? Well, one, we already know why they didn't put in the sound recording version of the work, because the Copyright Office wouldn't accept it, right? So then why would you come up with this crazy lead sheet mechanism? Well, because in many cases, and this is why this is so particularly important to American music, many American composers, they composed by ear, what I call they are oral composers. So they weren't fluent in musical notation. They couldn't write down a composition. Oh, they could compose thoroughly and quite deftly in terms of bringing the people together and putting it together on a sound recording. So now the recording company, which of course has been assigned, the copyright, so they have a vested interest in protecting this, they're caught in between this rock and a hard place. The only thing that we can submit to protect the work, at least to get a deposit in, the only thing that would satisfy that requirement is a written piece of paper. But the composer doesn't know how to do that. And so they would have these staff musicians, these composers on staff, who would do what Sean has accurately characterized as a quick and dirty. something to get into the Copyright Office as a placeholder. But at no point is there anything in the statute, there's nothing in the Copyright Office regulation, there's nothing in the case law that indicates that that placeholder for registration purposes was ever intended to supersede the actual complete work.
Yeah, and just to clarify that, this is not just an idiosyncrasy in this case, right? This is
Right.
pretty prevalent, common practice. I've heard of fake books go back to Italian. I mean, they go back quite a bit, right? So this is kind of interesting historical practice because I guess the adoption of written music was also something that took some time over. And so if I understand Pharrell Williams' argument, the copyright infringer's argument in this case, their argument is that their work was not similar to the lead sheet. Is that an accurate? And so the argument then that prevails from Marvin Gaye is that if you look at the entire work, sort of the touch, the look and feel, the concept, could you talk a little bit more about that and how that plays out in terms of copyright infringement? So they're not limited to what they register, but it may be something broader than that, either on a non-literal theory or some other notion about the effect or the legal effect of the registration.
Yeah. Well, since a lot of that involves what the musicologists, experts, what they gave evidence to and their musical extrapolations, let me let Sean start in with that.
Sure,
Because
I didn't mean to.
yeah.
You know, I forgot to mention that Sean has had a very big career as a rock star, literally rock star in the law field as well as a literal rock star, right?
Yeah.
And you still have your band, right, in Seattle now that you perform?
Yeah, I do. Yes.
So
Still playing.
expert at many levels.
Yeah, I'd
Just as a
like to know whether he has groupies, but he can tell us that offline.
That'll be in the blooper reel for the.
Right.
Yeah, so let's be clear, though, that the ruling in the trial court here was that the composition, for purposes of what was being viewed to be infringed or not, was just the lead sheet here. Okay? So, at the trial court level, the only thing that could be considered was the lead sheet. Now, the real question that was in the trial court, though, was, what do we mean by what's in the lead sheet? Okay, so it becomes almost like the way we, metaphysically parse words on the patent side. What does board or plank mean? What does individual words mean? And that's similar to here. And so the judge clearly said, has to be in here. And then the difference was what Pharrell and Robin Thicke and their experts said was in here, and what they then put together as a performance, a recorded performance of what was in here, versus then what the Gaye Estates experts said was in here. Now, what's really important is that on the Pharrell Williams and Robin Thicke side, they wanted to run an argument that it has to be very literal, like all you get are the notes that are here, and it's not even clear, what you do with something like the A7, okay? And so that's problematic because the way I view it is I say what you see here literally is not even a minimally viable composition, meaning unless this were just a chant or like an old Irish jig or something where it really is just one melody line and no other instruments, then you have to realize that there's other stuff here. Okay, so now for example, with the A7 here, this has to be interpreted. In other words, there is no direction to the person playing a piano or guitar or anything as to how this is supposed to be played. Now, if we go back to our commercial sheet music, now we see that there is a lot of direction. These right here are the chords, is what you're supposed to be doing with this A7. But now let's make a further problem, which is that, okay, so we need to extrapolate from this notation here, this A7, to know what the heck that even means to play. But then when we do that, do we do it in some kind of purely mechanical fashion with this, or do we have to even further figure out how the feel of this song was supposed to go? So let me now play you for a moment. This is a point about how standard sheet music like this, Western notation, doesn't track 20th century popular, especially African-American inspired music. And so let's play for a moment the So when you go to a site to get this sheet music, it will demonstrate it for you by having essentially an algorithm play this. So I'm going to show you what this sounds like according to the algorithm. Now, I don't know about you, but that's not even karaoke grade kind of accompaniment, right? You hear how it's so stilted, like that. It makes it sound like, back in the old days, it's a vinyl record that's skipping, okay? So now go to either song, Blurred Lines or Got to Give It Up, and that's not what's happening there, okay? So this shows you then the limitations of the actual music. So the big debate at the trial court then was, okay, what are we going to play for the jury to say what this is? Well, and not even this, what this is. Because we know that the jury's not expected to read sheet music, so they just look at this and say, okay, we don't know what any of this means, so you got to play us something. And then the debate comes down to what gets played. The judge says it can't be the actual final recorded songs because a lot of what's on Got to Give It Up doesn't appear at all in this. There's not even a hint of what the percussion is, for example. But then the gay estate says, okay, but it can't be completely just literally this played by an algorithm either. So that's a heart of the debate. Let me add one point before then turning it back to both of you. What was really important for me in this case, in looking at it, is that this is an unusual lead sheet. Why is it unusual? Well, because in most lead sheets, they only focus on that one vocal melody line, and they just give the chord names, and then that's kind of it. This one, though, has, it may be hard to see on your screen, it says bass intro right there. And then it's got, notice now, right here, there's a little signature, there's a bass clef. So this means play this in the bass register, in the lower bass register. Here are your notes. And this is the key bass hook that starts and runs throughout the song. And it goes to here, and then it says bass simile, meaning play throughout like this. So this means that even this kind of paid scribe at the publishing house, listening to the recordings from Marvin Gaye, said, oh, hey, that sounds pretty darn important, that bass line. So I'm going to make sure that's in the lead sheet. And then we go through all the melody. So this is key when you hear people arguing about what the bass line is or whether it should be in or not. It should be in because it's notated here. And it also should be treated as quite important because even the publishing house on a sparse lead sheet decided to put it in.
Yeah, and I think that sums it up excellently, Sean. One of the reasons why I wanted Sean to explain it musically for us is because, for those of us who are not musicians, I think it makes it a little bit more accessible now when we look at it, from the point of view of an analogy, right? I mean, so for example, if I'm going to write a book instructing people how to do a particular task, right? There is a version that I might write, carpentry for dummies, and then there's a version that I might write carpentry for experts. Anybody who's ever done carpentry, they understand the difference between those two works, right? And they understand that one work is going to leave out, many details, because the presumption is that all you have to do is just say this, and then an experienced carpenter is going to know this is the next step. So the point of view that from my position that I think that Williams and Thick want to take is that they want to look at a work that everybody in the industry knows is written in a certain way to perform a particular function. That they know that, as Sean pointed out, okay, well, how do you play that A7? Has been left out, right? Mm-hmm. But now they want to take the position that, oh, no, what is written, which anybody in the music business or any musician would know, that's unusable, right? There's a lot of additional creative material. These are just pointers, right? It's really no different than, for example, if you're going to do a recipe as cooking instructions, right? I mean, there are some that are really, really, like for those of you who are old enough, remember the Galloping Gourmet back in the 1970s, that, very flowery, tells you every little thing, and make sure that when you sprinkle the flour, don't forget to stick your pinky out, right? There can be those types of instructions, right? But then there can be much more Spartan, instructions. And it really is just legally disingenuous to try to argue that everything in the work is on this lead sheet.
That's what's really fascinating about this case. Well, in a few minutes, we'll talk about some of the implications for other things like software. We're talking about that and other issues because if you think about it, within the context of the technology transfer or dissemination of works, whatever the broader rubric is, there are a lot of really interesting conflicts here. There's a conflict here between different traditions of music, as you mentioned, the written music, the sheet music versus more of a oral AU tradition that arises. There's a conflict between what's required by the law and how people actually create things.
Yes.
You talk a little bit about traditions and recognition in your Seattle Times editorial about recognition for African American traditions and musical traditions that aren't necessarily captured very well by the law. And let me just talk about that, and we can go to the other two in a minute. One of the things that I found interesting about this is that about that point is that there seems to be a generational aspect of this, right? I don't know. I mean, I know Marvin Gaye's work. Listened to a lot of it. I've listened to Pharrell Williams a little bit less. But I was, researching Pharrell Williams a little bit. He's got a very, interesting background. Families who had ties to Liberia. I mean, I think he was born in Virginia, but I think freed slaves who had gone to Liberia back in the 19th century. And so there seems to also be a sort of a generational conflict here within maybe the African American music tradition very broadly. Did you want to comment on that? Sean may not have benefit. Lateef and I talked about this a little bit earlier. But
Yeah, I mean, it definitely is an important issue, and admittedly, it's something of a dicey, touchy issue. Obviously, in any culture, particularly in a marginalized culture, there are going to be concepts as to who are the curators of the culture. And you're absolutely right. There are certainly certain generational differences that are emerging here in terms of, okay, what does someone, of Pharrell's generation, what do you perceive as your curation responsibility to this music? I mean, there's never been any dispute that the driving composing force behind Blurred Lines was Pharrell Williams. All right, Pharrell Williams is a member of a community and has access and experience and a sort of a historical interface, with that music, and did or ought to have a greater appreciation for, well, what are the creative elements, et cetera, et cetera. And when are you crossing the line from inspiration and homage to outright copying? And so, from some perspectives, perhaps a larger share of the responsibility of this infringement faux pas, if indeed it was unintentional, could largely rest on his shoulders.
Sean, did you have any thoughts on that?
Yeah, so I think that one of the issues, and I see we actually have a question has popped up here too.
You want to go to the question, or is that
Okay?
Yeah, the question that
Well, it actually does.
Yeah.
Yeah, because the real.
I'll read the question.
Yeah. So the issue. Sure. Yeah, you can read the question.
So the question that just popped up from one of our listeners is, what are the implications of this case for future composers?
Yeah. And so following off of what Lateef was putting so nicely there about curating and generation to generation, what we're really, I'm going to abstract that a little bit and say it's an upstream, downstream problem, just like we have in inventions and commercialization there. And so let's look a little bit now at the genre question, because a lot of people who critique this case, the trial court decision in Got to Give It Up, are saying that, oh my gosh, you've put off limits an entire genre, a style. And the problem first is that we need to distinguish those two things. A composer has an individual style, okay? And it's true that that's not supposed to be protectable in copyright, but that individual style is not a genre. At least it's not a genre yet. And so one of the challenges you have, particularly with the song Got to Give It Up, is that like in patents where you have to be careful of hindsight bias, Got to Give It Up from today's perspective, especially for people who follow R&B and soul genres, You can say it may look like it really became a genre, but when it came out, it was experimental. And what Professor Ingrid Monson, one of the experts for the gay estate family, said was that when you look at the different rhythms that he put together, it was not anything that existed in a genre then. So in other words, it was not a genre piece. And so if you copy those, what were elements from different genres being mashed up together, you're not copying a genre there. You're copying somebody's particular taking of different genre elements and then putting them together in a novel way. But here becomes the problem, and this is Amanda's question then is, okay, well, that sounds fine, but then how long do we close off this thing that now becomes a genre? And so an example I often use is the famous Girl from Mtima recording with Joachim Gilberto and Stan Getz. And Gilberto is basically creating a whole new kind of bossa nova that will really take over Latin music and be very popular in the US. But when that first album comes out, often called the Black Album because of the cover on it, it's not a genre yet. And so this is just like on the patent side. So you have, Alexander Graham Bell patents parts of a telephone, not really the whole telephone, but he does that and you say, oh my gosh, later on, how can you patent a telephone? It's the whole entire industry. So I know that I'm not in some ways answering the question, but I'm saying this is the tension, and I think we have to give due where it's best set for people who are creating something that may become a genre. And then we have to deal with that tension a little bit later on to say, okay, so what are the elements now that are generic to the genre, and what are the things that are still tied to that particular composition? And so that's what the experts were trying to do in this case, is separate out things that later became part of a genre from the things that were quite unique to what Marvin Gaye was doing.
And let me build upon that by not only building on that, but also adding some on the response to the online question.
Right.
First, Sean makes an excellent point, because not only is that a very important point for music, but also to tie it a little bit to some of what you're going to get into a little bit later, implications for technologies in other areas.
Right.
This same issue arose in the Google versus Oracle, or Oracle versus Google dispute.
Right.
And that very issue was ultimately addressed by the court, and the court decided, there may be some things that have become standards in the industry today. There may be some things that have become scenes of fare in terms of the way you organize and structure the non-literal elements of a software program.
Yeah.
But you don't get to look at it from the perspective of today. You have to look at it as to whether or not it was original and innovative as of the time when Oracle first structured the program. Okay, so it's the same issue, which was exactly the point that Sean is making. Two other quick, sort of related things is a lot of this, we keep talking about this non-literal, aspect. And one of the things that is so important about this is that, again, the statute says whatever is creative, that's what gets protected. Copyright jurisprudence, past 200 years, said, well, just as Sean was discussing in terms of the doctrine of equivalence, we do have a non-literal protection doctrine under copyright, right? Obviously, you can take creative elements from a work without copying the exact sentences, right? And these aspects could be, these characteristics could be aspects of the author's creativity. And if you could misappropriate them simply because you didn't use the exact sentence, well, you could engage in a whole lot of copyright infringement. So we have a test in copyright infringement to protect non-literal creativity in addition to literal creativity. What gets interesting, right, is that we've already come to understand in the 1990s that trying to apply the protective test for non-literal elements of a traditional literary work, like a novel or a play, that doesn't work if you're looking at something like a computer software program. So what did we do? We came up with the Altai test and some other tests to say this is how we protect those elements in a very different type of work, recognizing that the traditional non-literal tests don't work here. So one of the things that this case illustrates for us is that a big part of the problem is that we do need to come up with a test to protect the non-literal elements in a musical composition because they are entitled to protection under the copyright statute. But that test cannot be a test that is dictated by one specific group of the musicology world, coming at it from one specific and perhaps even biased perspective, with them labeling what is creative and what is not creative. And then the last point, which I think most directly answers the question, whenever you have entities who are entrenched in the present and enduring system, the minute that there's something that's going to challenge their interests, they come in with this sky is falling, argument. Oh, if this continues, oh, you new young song makers coming, you're going to be permanently hemmed in. One of the things that people overlook is how do today's musicians compose? Most of them are not fluent in musical notation, right? Indeed, and I'm not saying this is necessarily a good thing, many of them don't even know how to play musical instruments, right? Okay, so actually a decision that de-emphasizes musical notation as the deciding factor actually benefits the creativity of today's composers because they really have the least vested interest in literal music notation being the coin of the realm. So actually, this is actually good for future composers from my perspective.
Yes, but as music becomes more digital, isn't there a tendency to become more like, as Sean was showing with the ... that it does become more analytical and less this concept and feel? I mean, there's an argument to be made that music is increasingly sounding more alike, right? So how do we ever disentangle copyright infringement and that?
Right.
And that may be the import of Amanda's question a little bit in terms of future composers.
Well, of course, that just goes back to what the central question is.
Yeah.
Okay, what aspect of a work, literal or non-literal?
Right.
What aspect is creative?
Right.
Okay, so if in the digital world, if you end up having sort of like craft work, that whole type of German rock, if a fair amount of it is simply repetitive and is non-creative, well, again, it doesn't matter to the copyright statute whether it is literal or non-literal. It's not original. It's not creative. It doesn't get protection. The mere fact, though, in some cases, like this case, they present hard cases, okay, which is what Sean was talking about. How do we sift out those aspects of the genre that were original as of the time when Marvin Gaye developed it? Right. The fact that it presents a hard case doesn't mean that we get to say, oh, it's too hard, let's not do it. Let's just toss all of that over into the uncreative pot.
Let's talk about another dimension, and this get us to other types of creative works. I mean, talk about digital sampling. Would this case have some implications for digital sampling? Are those cases better treated as fair use type cases?
Those are quite different because they're about the sound recording, right?
Okay, right.
And now sampling in some ways could almost be easier because you're really just looking to see if the actual recorded material was used somehow in another recording. So this doesn't have a lot for that. The only connection would be, though, that if you, and some composers do this, where they really are just doing a true mashup of it's all samples and nothing is, and I think Lateef was kind of alluding to this, then it's interesting because none of those samples are original to the composer, but yet do we still allow them, and I think maybe we should, allow them an overall copyright for the total kind of look and feel, in this case, sound and feel, as long as those things are put together in an original way.
Yeah, this is a big. This is a big problem. You mentioned Lateef, the Oracle versus Google case. I mean, one of the annoying questions in that case for people who think came out wrong is, can you take a bunch of things that are non-copyrightable, put them together to come up with something? When does that occur, right? And so that's
right.
I mean, that's where the kind of to just defend Pharrell Williams' point. There's something helpful to say. Well, you kind of stuck with this, right? I mean, the literal sort of.
Yeah, and the thing of it is that this is an issue that arises in pretty much all fields of IP, and all fields of IP have ways of addressing it. I mean, for example, in trade secret, right? You can take elements, okay, that are known, right? But if you're going to assemble them in a way that is novel and not known, all right, there's ample case law that you get protection for that. Really, what the IP law is seeking to do, copyright and all the others, is we're seeking to identify, well, where is the originality? Right. Where is the creativity? Right. Okay? And I think the bottom line here is that even if in a particular case it is difficult to sift it out because the finder of fact or the expert is not necessarily completely familiar with it, the Copyright Act doesn't let us off the hook. It doesn't give a coupon to the biased musicologist to simply say, that's too mushy. We just won't grant that any protection. We always have to do the hard work in hard cases. And outside of some sort of bias against the creative output of marginalized groups, there's no reason to punt that responsibility when it comes to this musical genre, because we certainly wouldn't do it in any of the traditional Western musical genres.
Sean, did you want to?
Yeah, so I just want to add 2 points. One is that you can look at then ultimately copyright in two levels that the copyright could be happening. One would be that you're looking at a particular element like this baseline. And this is the analysis where you say, let's look at element by element, and then look at the melody line, whatever else is notated or considered to be part of the copyright, and see if that particular thing is infringed, copied in the other thing. But you can also look at it, and Shubert, you quite rightly bring up the problem of a completely digital composition, then a complete mashup, that then maybe none of these elements are creative in and of themselves, or at least they're creative to somebody else. And I think we're all saying that the law as it stands now says that overall you get kind of a compilation copyright. Yeah. But here's the rub, and this goes back a little bit to Amanda's question then, but unfortunately may muddy the waters, is you get a very interesting, almost thin copyright on the compilation though, because then it's only infringed, I think, if you have all or almost all of those generic elements put together. So I don't think we necessarily have to fear that if there is a compilation kind of overall putting it together copyright, that's going to be the end of composition. But I also do want to point out that when you actually look at the Gay Estates expert testimony, they're not actually arguing that. They're arguing very specific things like this baseline, and that it is, in fact, mimicked by that. So that's why, commentators have been saying this is all about style genre, but you dig into the pleadings and the expert testimony, and it's actually really not about genre style or about compilation at all. It really is about individual elements that then, and you could disagree on that. A jury could disagree on whether those individual elements, whether they're convinced they were infringed or not. This jury was convinced those individual elements were infringed.
Just to sort of pick up as a last, on that point, I think to drill down even deeper, because I really like the way that Sean put it, I think another issue that is arising and is being revealed here is that perhaps there has been a tradition in these sort of disputes in which oftentimes, our co-author in the Seattle Times piece is Lita Rosario. She is an entertainment lawyer, and I asked her about this, and I said, what happens in other cases? How come we haven't seen this sort of clash of musicologists before? And she says, typically when it comes to the R&B artists, they typically either can't afford the resources to hire musicologists, or they don't have a sufficient understanding of the way music works, again, because they're not literal in music notation, to bring a musicologist into the dispute. Excuse me. So I think that what this may also be revealing, right, to go right back to Sean's point that, hey, the musicologists were saying, hey, no, look, this bass line, this is creative, et cetera, et cetera. What may have been happening is that you're having musicologists, either because they're biased or just not familiar with this particular work, there are things that they have been arbitrarily labeling. Oh, that's just style, that's the genre, right? But then when someone who is equally trained, a musician like Sean or the type of musicologist that testified in the music estate, they peel back the cover and say, wait a second, this is not style or genre, and I know what I'm talking about because I'm an expert too.
Yeah.
And that's why this ended up before the jury. You actually have dueling musicologists, each coming out with a different conclusion on the extrinsic aspect of the test, which leaves the court with no choice but to say, this expert says that expert says this. Jury, who do you think is more credible? And that's really all that happened in this case.
Yeah, and then but the total concept and feel really kind of, I don't know if it bends it in one direction or not, but you can make the case that it's probably pro copyright owner, right? I mean, it's going to you're more likely to find something original when you look at the whole thing than if you're asked to sort of take it apart or dissect it. Well, thank you for that question, man. We'll look for other questions as well. We have about 15 minutes left, and I wanted to kind of turn this. I was really interested in doing this webinar just because this case is inherently interesting, and I get to converse with two people who've been very actively involved in various aspects of this. But it also has other implications for other areas of copyright and intellectual property. And we touched a little bit about software, but we can talk a little bit more about software. But I also want to talk about design. I mean, there are two big design cases in front of the Supreme Court, and we've had past webinars on them, and we'll have a future webinar on both the Samsung case and on the Star Athletic, or better known as the cheerleader costume case. It seems like in those cases, one of the big issues is whether you should dissect the work, how to what extent can you, certainly with the design copyright cases, when is something a useful article and when is it a standalone work of art. And then even in the Samsung case, the basic issue is, do you get the whole, if you get a design patent on one component, and do you get the whole thing? I mean, this is the cup holder Rolls-Royce problem, right? So did you want to comment on that? Do you think there is any implication, or is it better to think about these in terms of cubby holes? So this is just a music case, and it really doesn't have any bigger implications for what's going on in the law right now. Either people?
Well, for me, I don't see a great deal of overlap in these cases for this reason, that whereas in this case, Blurred Lines case, we're really looking at what's creative protectable versus uncreative non-protectable, which really goes to the heart of the raison d'etre of copyright, expressive, aesthetic, artistic. Whereas in the design cases, you're adding a different element. It's sort of like, utilitarian versus expressive. And the utilitarian aspect, of course, isn't present. I think, so that's why I see them as different. Of course, the tough issue in those cases is that, well, are they always mutually exclusive? Just because something is utilitarian, does that mean it cannot be expressive? But then, we could go down, no pun intended, but we could go down the rabbit hole of Alice, the software patent case. So, I think that takes us in a whole nother light. But I don't know what Sean thinks.
Well, I think, to the extent there's some overlap, it really is staying with this theme about, kind of what's in the official document that you use to procure your rights. Then it becomes interesting to look at software itself as far as the Copyright Office does allow, and I think Lateef has much more expertise on this than I do, but in allowing only segments of the code, or essentially a placeholder. You don't have to put the whole million lines of code in, of source code in. So that is quite similar to what we're talking about here with a lead sheet. This is an indicator, it's a placeholder. Now we jump over to patents, regular old utility patents, not even design patents, and we look in DNA, and something similar happens there, where you don't have to put in all of the entire sequence of DNA. You can put in just enough that then the patent office feels like they have enough of an identifier for it. So this is one of the challenges that really strikes at the heart of intellectual property. And it's actually related to this book project I'm supposed to be finishing here in Strasbourg, actually, which is the tension between codification of knowledge and experience and the actual knowledge or experience. And I don't want to get too metaphysical, but it's an important point for IP, which is that even the claims of an invention, even the idea about the invention space, it's not just the embodiment, it's the invention space, that's a little weird in a way. What is that in the real world? And as soon as you start writing claims or trying to describe an invention or a method as an invention in words, already it's one level of abstraction. So Lateef is perfectly right to bring up Alice and the abstraction problem. And this is all over here. This is an abstraction too. Is this the experience of music? No, and we know that the problem with trying to use this kind of notation and doing learned hands kind of line up the notes and see if it matches as if it's an algorithmic kind of thing, you can show that what looks to be the same sequence here can actually sound different, and vice versa, something that looks different on paper can sound quite similar. So what we're all grappling with here is how do you codify and capture experience things in the world, capture them to send into a government agency to then say, this is that thing. And then decades later, go back and figure out whether what you sent into that government agency really works or not to capture that thing.
Just to kind of getting to the wrap-up phase of our discussion, there's sort of a lesson for lawyers in this, and how do you represent clients in this space, in all of these different areas, not just simply music, but in software. At what point does the lawyer sort of get involved and, either play mop-up? I mean, they either try to figure out where the clients may have gone astray or kind of looking forward in a more positive way. And then also kind of what the world of the creative person is, right? So some of the design copyright cases, they look to see what the intent of the creator was and so forth, and for various, whatever weight that might have. So it's very interesting to think about that perspective. I guess since it's a kind of a neat way to wrap up, and that is, when you look at a lot of these copyright cases, not this one, not just simply the one between the dispute between Gay and Williams, somebody gets labeled an infringer, and there is this kind of aura of, oh my God, they weren't creative, and they were, stealing somebody's work, they were plagiarizing. And we know it's more complicated than that. But if you were to sort of go back in time, is there any piece of advice you could give to Pharrell Williams and to Robin Thicke to, sort of benefit of foresight, if you will, in this case? And this is kind of going back to Amanda's question a little bit about future composers. Why don't we end on sort of that note?
Yeah. Okay. Well, there are three quick things that I would say. I think that what has obviously come to the, bubbled up to the top is that there really isn't a matchup between the legal codification process and the creative process, right? We really are trying to fit a square peg, round hole, that sort of thing. And so the best advice you can give to a creator is, you go ahead and you create. It's my job to help you record that, manifest that as closely with the directives of the IP process. And then, of course, later on, hindsight, shouldn't be controlling. Fact finders and arbiters, have to keep that in mind, that there is something that's not quite a complete matchup. In terms of subsequent composers, one of the things that we also have to keep in mind is to remind them that we now live in a post-eBay versus Merck exchange world. I mean, the mere fact that you have inadvertently, infringed, it doesn't mean that now we pull your work from the shelves. It just means that the only thing you're going to be obligated to do in most cases is just to share a portion of the revenue. So you can just keep producing, so we're not going to stunt creativity.
Being the case about injunctive relief.
Right, injunctive relief, right, no longer an automatic remedy. And then lastly, in terms of the whole stigma, George Harrison has not lost his place in history because of the He's So Fine case. We do recognize that sometimes these things happen inadvertently.
Yeah, my point wasn't so much was about the stigma. That was sort of just to maybe dramatize a little bit. It's just that, as you said, it's inadvertent.
Yeah.
I mean, I don't think Pharrell Williams. I mean, you don't have. It's different type of infringement than being in your condo grinding out
Exactly.
Copies of DVDs or something, right? Which we think, okay, that's clearly not original.
Right.
So it's that aspect of that. Is there? I mean, I think what I read from you, Lateef, is that composers should just do what they do.
Exactly.
And then if there is a legal dispute, we have to come up with legal standards that sort of clean up things if the composer kind of goes astray. But we don't want to. We don't want to limit that in some way. Sean.
So I'll take a slightly different approach and say that in the end, and hopefully this will actually finally answer Amanda's question better.
We've been asking. answering your question in the last 20 minutes, but it's fine. It's a good question.
Um, it really is, it is non-legal in that way, but it's that listen to your friends, associates, and colleagues, because I'm going to say, and this is just me speaking as a musician and as a former songwriter, having hung out with a lot of those folks. I hate to say it, but everyone knows you have enough people in your circle that before you release the darn record, play it, and somebody's going to go, "Hey, that sounds like whatever." And I've had it happen to me, and it was totally inadvertent. But after I listen, I'm like, yeah. Sometimes you listen and say, "No, that's bunk. It doesn't sound anything at all like that." But somebody is almost always going to catch it, and so I think that what's interesting in a lot of these cases. And I think this was there was some hint, I thought, even in the George Harrison case, that somebody had pointed out to him, hey, it kind of sounds like that. And sometimes you just go, I'm going to do it anyway. And I think that's a bad idea. So in other words, listen, and if nothing else, do it because, Shuba, as you're getting it, you want to be seen as a creative individual. As a songwriter, I don't want people to say, oh, that's derivative pablum. That guy's just, even if I can get away with it as a copyright matter, I don't want to be seen as the guy who just slavishly copies other people's styles and elements. So that's really my advice is, send your stuff around, have a bunch of people listen to it before you finally publish it and put it out there. And take to heart if somebody says, hey, that sounds like a riff from wherever.
Let me just follow up on that with one just quick question that's probably relevant to a lot of our audience. If they do find the similarity, a friend points that out, I mean, is there any situation where they'd seek a license, or is that maybe unrealistic in many, unless you're Weird Al Yankovic or something? I mean,
Yeah, I mean, look, the one thing you can do is, it gets a little difficult because it gets around the intent, and if somebody's pointing it out to you, it means you didn't intend to do it. But if you did intend to do it, and you're just quoting a short snippet, and you're making commentary on it, because musicians and composers do what we call talk to each other when we write, and we do things like, hey, you slip in a little riff so that people will get the reference. If you do that, that's straight on fair use, jumping back to the legal copyright side. Okay, so that's something that can be in the mix here. But at the same time, then, if you didn't intend it to be that, and getting a license is going to be hard because you're most likely not copying that much of the original song. So in other words, a license is normally when I'm going to do something that goes beyond a cover, but I'm really going to adapt this thing. So it's going to be hard to get the license in a lot of cases, and could be expensive. So I don't know. I'm not ruling it out, but I think that it's probably better you can so easily tweak the part to get a little further away that I think that's the best way to go.
great. Well, we've covered a lot of ground here, so thank you both. Thank you, Sean, for taking the time out. A little break from your sabbatical, but thank you for crossing the time zone and things. Thank you, Lateef, for making the trip up from Washington, D.C.
Thanks for having me.
Hopefully,
Thanks for having us on.
Future webinars. We'll send out a notice soon about future webinars this semester, but I'm planning one next January to deal with patent law and climate change issues with Professor Josh Sharnoff at DePaul Law School. So I'm hoping that will come to fruition. But please look out for notices, and please feel free to contact me or the center if there are any questions or suggestions. So thank you for your attention for folks out there, and thanks once again, Sean. And thanks.
Thank you.